so empty. The only thing I see is my own silhouette.
Judgment. Crawford Adjusters and others, appellants, v. Sagicor General Insurance, Cayman, Limited and another, respondent. Respondent. From the Cayman Islands Court of Appeal before Lord Neuberger, Lady Hale, Lord Kerr, Lord Wilson, Lord Sumption. Judgments delivered on June 13, 2013, heard on 22 to 23 January 2013. Appellant Respondent Isaac Ellis, Jacob Michael Roberts, Con Maceville, Lee Nicholas Dunn, instructed by Hampson and instructed by Edwin Coco, Attorneys at Law, LLP, as agents for Georgetown, Walkers, Georgetown. Lord Wilson. Introduction. 1. This appeal requires the Board to consider the scope of the closely related torts of abuse of process and malicious prosecution. 2. The appellants are Mr. Alastair Patterson and 2 companies of which he is a director and which at all material times acted by him. For the purposes of this appeal I will personify all the appellants as Mr. Patterson. 3. The respondent is Sagicor General Insurance, Cayman, Ltd., Sagicor. 4. Mr. Patterson appeals against an order of the Cayman Islands Court of Appeal, Cayman Islands, dated April 5, 2012. By a judgment delivered by Sir Anthony Campbell J.A., with which Sir John Chadwick P. and Elliot Motley J.A. agreed, the court dismissed Mr. Patterson's appeal against an order of the Grand Court of the Cayman Islands dated February 14, 2011. By a judgment delivered on that date, Henderson J. had dismissed Mr. Patterson's counterclaim against Sagicor for damages. The facts. 5. Mr. Patterson is a chartered surveyor resident in the Cayman Islands. Made landfall in Grand Cayman and caused substantial damage. It extensively damaged Windsor Village, the village, a development of 35 residential units in 6 two-story blocks along the shore. The proprietors of the village had insured it with Sagicor against damage, including by hurricane. 7. Sagicor at once accepted that much of the damage caused to the village was covered by the policy. On September 24, 2004 it appointed Mr. Patterson to act as its loss adjuster in relation to the claim. Mr. Scott, the chief executive officer of Sagicor, resided in the village and was keen that the works of restoration should begin quickly. It was he who suggested that the works might be undertaken by one or other of 2 building companies of which Messrs. John and Robert Hurlstone were directors. I will describe both companies and both men compendiously as Hurlstone. 1. 8. Sagicor and the proprietors of the village were both content that Hurlstone should undertake the works. It began the initial cleanup work on about October 21, 2004. But in the aftermath of the hurricane there was considerable chaos on the island. Building materials were in short supply and their cost had increased sharply. Little heavy equipment remained in working order. There was a severe shortage of motor vehicles. Construction workers were hard to find. Hurlstone had to employ hotel and bar workers, who demanded higher than normal hourly rates of pay. Water had devastated Hurlstone's offices and its computers had been destroyed. 9. It was partly for these reasons that paperwork apt to a project of such size was lacking. Engineers had produced a structural report and drawings for the reconstruction, but a detailed scope of works was never produced and its absence caused considerable difficulty. A total contract price was never agreed between Hurlstone and the proprietors of the village. The absence of specifications and bills of quantities disabled Hurlstone from offering a firm price. But in November 2004 it gave the proprietors a preliminary estimate in the sum of just over $5.5 million, and the estimate came to Sagicor's attention. In this judgment all references to dollars are references to Cayman Islands dollars. 10. Hurlstone made clear to Mr. Patterson and through him to Sagicor that it expected payments in advance to cover its likely expenditure. Between October 2004 and May 2005, on the recommendation of Mr. Patterson, Sagicor made 7 advance payments to Hurlstone which totaled $2.9 million. The final 3 of the payments were also approved by another loss adjuster instructed by Sagicor, although he expressed concern about the lack of detail in Mr. Patterson's reports. Before recommending advances to Hurlstone, Mr. Patterson visited its offices, inspected its invoices and sought carefully to review its work. By June 2005 Mr. Patterson was close to finalizing his adjustment of Sagicor's liability. Liability under the policy. For discussion he put forward figures, which Sagicor appeared to accept, that the total cost of the works of reconstruction at the village would be in the sum of $6.5 million, of which Sagicor would be liable for $5.5 million. Hurlstone was pressing for a further advance on the basis that the total of the previous advances fell significantly short of the value of the works which it had so far done, but Mr. Patterson agreed with Sagicor that no further advance would be made until a contract price had been agreed. 11 In June 2005 Mr. Frank D'Alessio joined Sagicor as Senior Vice President. He was an experienced and able loss adjuster with an aggressive personality. He and Mr. Patterson had known each other for several years. They were not fond of each other. Like many others, Mr. Patterson considered Mr. D'Alessio to be confrontational. In about 2001 Mr. Patterson had inquired of the Cayman Immigration Department whether Mr. D'Alessio held an appropriate work permit, and his inquiry had come to Mr. D'Alessio's knowledge. 12 On arrival at Sagicor Mr. D'Alessio began a detailed study of its liability for losses caused by the hurricane and in particular for the cost of works at the village. He became concerned that there was a serious deficiency in the documentation to support the advance. 2. Payments which had been made to Hurlstone on the recommendation of Mr. Patterson. On behalf of Sagicor Mr. D'Alessio instructed Mr. Patterson to deal only with himself. He acquired scope sheets apparent. Payments which had been made to Hurlstone on the recommendation of Mr. Patterson. On behalf of Sagicor Mr. D'Alessio instructed Mr. Patterson to deal only with himself. He acquired scope sheets apparently prepared on behalf of Mr. Patterson, which appeared to calculate Sagicor's total liability at $4.8 million rather than $5.5 million. He demanded that Mr. Patterson should at once provide a full report outlining all costings. By that stage it would have been almost impossible for Mr. Patterson to meet that demand, and, insofar as he could have met it in part, he could not have done so quickly. 13 In July 2005, apparently with the agreement of the proprietors, Mr. D'Alessio told Hurlstone that it had been fired. It had completed about half the work and had expected to finish it in December 2005. 14 In July 2005 Mr. D'Alessio stated that he intended to drive Mr. Patterson out of business and to destroy him professionally. The judge found that Mr. D'Alessio meant what he said. To one witness Mr. D'Alessio seemed obsessed by a desire to damage Mr. Patterson. He arranged for private investigators to place Mr. Patterson under surveillance. He caused Sagicor to instruct Quinn and Hampson, attorneys at law, to advise it, and, in its dealings with the attorneys, Sagicor acted through him. At its invitation the head of the Financial Crimes Unit of the Islands Police Service attended a meeting between him and the attorneys in case it should be concluded that Mr. Patterson had committed a criminal offense. 15 In August 2005 Mr. D'Alessio instructed Mr. Purbrick, a chartered surveyor and loss adjuster in practice in England, to come to Grand Cayman and to assess the value of Hurlstone's work at the village. Mr. Purbrick spent 5 days on site. But, on the instruction of Mr. D'Alessio, he did not speak to Mr. Patterson or Hurlstone. Nor did he inquire of Hurlstone. Hurlstone's subcontractors or suppliers about costs. Nor did he even consult the engineers who had produced the structural report and the drawings. 16 In September 2005 Mr. Purbrick produced a preliminary report. In it he valued the work done by Hurlstone at $0.9 million, of which $0.8 million was said to be the responsibility of Sagicor. On Mr. D'Alessio's instruction Mr. Purbrick had made no allowance for the cost of any clean-up work. Mr. D'Alessio thereupon caused the attorneys to instruct London Council to advise whether Mr. Patterson and Hurlstone had perpetrated a fraud on Sagicor. On the basis of Mr. Purbrick's report Council advised that Hurlstone's overcharging, approved by Mr. Patterson, had been so gross as to be incapable of honest explanation. In about February 2006 Mr. Purbrick wrote a second report in which he identified allegedly defective work by Hurlstone which caused him to reduce his estimate of the value of the work which it had done to $0.8 million, of which $0.7 million was said to be the responsibility of Sagicor. Both Sagicor and the proprietors of the village instructed the attorneys to issue proceedings on their Behalf. Payments which had been made to Hurlstone on the recommendation of Mr. Patterson. 13 in July 2005, apparently with the agreement of the proprietors. 14 in July, 15 in August 2005 Mr. Delisio instructed Mr. Purbrick, a chartered surveyor and law adjuster in practice in England, to come to Grand Cayman and to assess the value of Hurlstone's work at the village. Mr. Purbrick spent 5 days on site. But, on the instruction of Mr. Delisio, he did not speak to Mr. Patterson or Hurlstone. Nor did he inquire of Hurlstone's subcontractors or suppliers about costs. Nor did he even consult the engineers who had produced the structural report and the drawings. 16 in September 2005 Mr. Purbrick produced a preliminary report. In it he valued the work done by Hurlstone at $0.9 million, of which $0.8 million was said to be the responsibility of Sagicor. On Mr. Delisio's instruction Mr. Purbrick had made no allowance for the cost of any clean-up work. Mr. Delisio thereupon caused the attorneys to instruct London Council to advise whether Mr. Patterson and Hurlstone had perpetrated a fraud on Sagicor. On the basis of Mr. Purbrick's report Council advised that Hurlstone's overcharging, approved by Mr. Patterson, had been so gross as to be incapable of honest explanation. In about February 2006 Mr. Purbrick wrote a second report in which he identified allegedly defective work by Hurlstone which caused him to reduce his estimate of the value of the work which it had done to $0.8 million, of which $0.7 million was said to be the responsibility of Sagicor. Both Sagicor and the proprietors of the village instructed the attorneys to issue proceedings on their behalf. 3. 17 On February 28, 2006, in the Grand Court, Sagicor and the proprietors issued a writ against Mr. Patterson and Hurlstone. The statement of claim was squarely founded on Mr. Purbrick's reports. The plaintiffs alleged that Sagicor had paid Hurlstone $2.9 million for works for which it was liable to pay only $0.7 million, that the payments had been made as a result of fraudulent misrepresentations about the value of the works on the part of Mr. Patterson and Hurlstone, and that they had conspired together to make the misrepresentations. Sagicor claimed damages against them for deceit and conspiracy. The proprietors, however, soon amended their claim so that it was brought only against Hurlstone and only for breach of contract or by way of restitution, so to plant an article in the press about the allegations against Mr. Patterson and Hurlstone in the proceedings, and the judge found that he was instrumental in alerting a journalist working for the Caymanian Compass to the allegations. On March 22, 2006 the Compass duly reported Sagicor's allegations that Mr. Patterson had made misrepresentations which he knew were false or which he had made recklessly. The currency thereby given to the allegations caused massive damage to his reputation and to the willingness of third parties to employ him.